Hello and welcome to Tuesday morning learning. This is Rabbi Elton from the Great Synagogue in Sydney, but not in the Great Synagogue in Sydney. I'm having a few days holiday, but I didn't want that to interrupt our learning. So we're going to carry on our learning in Sefer HaChinuch, this description of all of the 613 mitzvot, all the commandments in the Torah. And this week we're looking at a mitzvah in the parashat of Masei, one of the two parashas we'll read this coming Shabbat, which contains an important principle in legal procedure and in fact the administration of justice in its higher sense. So this is the mitzvah 409. Shelo laharog mechuyav kodem shamod bedin. Not to execute somebody, even though they are guilty of the crime of which they're accused, before they have been put on trial. So the necessity for a fair trial before somebody is executed or in some other way punished for their deed. This is what the Chinuch says. We are instructed not to execute a sinner. Even though we've seen him commit a crime for which he is liable for the death penalty. Kodem before we bring him to Beis Din, before we bring him to the court. Aval nischayvnu lahavio lifnei Beis Din, rather than we are obliged to bring him before the court. V'navia alav ha'edim lifneihem, and to bring witnesses to testify against him. V'heim yidinuhu v'mei shehu chayav, and then the court will condemn him and sentence him for the sin for which he is liable. Shneimar, as the verse says in the parasha, Lo yamus harotzeach ad amdo lifnei ha'eda lemishpat. One must not kill the killer, the murderer, until he is stood before the community, represented through the Beis Din, through the court, for judgment or for justice. Lashon Mechilta, and now here is a quotation from the Mechilta, which is an early rabbinic commentary on the Torah, which brings out its legal points. It says, Yachol, sheharagu oso, misharag, or she'na'af. Maybe, you might think, one should put him to death from the moment when he either murders or commits another offence, rape or adultery, something like that. Tamad lomar, lo yamus harotzeach ad amdo v'gomer. Says, no, you can't just kill him because you've seen him commit the crime. There can never be any sort of vigilante justice, even if you see him with your own eyes commit the crime. Even in such a situation, you can't simply go out and kill him, or even kill him in the moment. You have to put him on trial. Now, there's a distinction there between killing somebody to prevent a crime, like murder, and killing somebody after the crime has been committed. If you see somebody charging towards somebody else with a loaded gun or with a knife, and they're going to kill the other person, you can kill them to prevent that crime taking place. That's called the din of Rodef, the law of a pursuer. But once the crime's been committed and he's no longer a danger to anybody else, you can't then go and perform vigilante justice. V'imra'uhu Beis Din hagadol sharag, and even if the entire Beth Din, if the court itself would be to see somebody commit a murder, for example, you kulam edim, they're all witnesses. They're no longer in the role of a court, because a court can't be the same as the witnesses. Rather, they are witnesses. V'yisu edosan etzel Beis Din acher sheid nuhu, and they then take the guy before another court, and they will be witnesses in that court. But they can't be both witnesses and sentencers, witnesses and judges. That's not appropriate. V'od amru b'Mechilta, and it says further in the Mechilta, this rabbinic commentary, Hare eda shero echad sherag es hanefesh. If the whole community, or the whole people, should see somebody commit a murder, Yachol shehargu oso ad shelo yamod. Still Beis Din. Maybe you should say that they can kill him. It was done in the face of the entire community. The whole population saw this happen. No. Tamad lomar lo yamos harotzech ad amdo. You could never ever kill somebody without them appearing before the court, even if the whole court saw it happen, even if the whole people saw it happen. There must always be this procedure through the Beth Din. Now, v'noheges mitzvah zo, this law applies. It applies to both men and women in all times. Sha'anu musharin shelo narog shum choter, afal pi sheri unuhu she'asa masa she's chayev misas based in. Even if we these days, and this is a law which applies even nowadays, even if we see somebody committing a particular crime, even murder, which the Torah says deserves the death penalty, why don't we these days go out and kill that person? Because even though the system of religious courts no longer exists in this sense, there are no longer religious courts for criminal offences, because there is no court, we can't take action into our own hands. In the absence of court, nothing can be done. There can be a civil procedure, that's different. But in terms of religious law, we are prevented from carrying out the sentences of the Torah in the absence of a system of courts which carries out adjudication and sentencing of criminal affairs. That's why we don't have executions in the Jewish community these days, because without a system of courts properly constituted, that is impossible. Now, when the temple was standing, anu chayavim lahavio leveistin v'hem yedinuhu, and when there were courts standing in the time of the temple, then we'd have to bring the person before the courts. V'over al zeh shahara go lachoter kodem shavo leveistin, and if one would take somebody's life without bringing them first to the court, afilu im hayadino sheis chayev beveistin, even if the court would have convicted them had it been placed before them, din shehargo kedin rotzeach, the person who carries out that execution, that non-sanctioned execution, is considered themselves as if they are a murderer. And if there were witnesses in the time of the temple, they themselves would be brought to the court and they would be executed. And now let's look briefly at some of the reasons or the underlying teachings or principles behind this mitzvah. Mishashe mitzvah, amongst the ideas or principles behind this mitzvah, levisha inyan dino nefashos hudava kashem od. When it comes to taking any person's life, even though that's obliged by the Torah in some cases, it's an extremely weighty matter, which requires extreme care and attention to detail. And it's tavu ha'eda lios matzilim hanidun b'chol davar sharu hatzilo b'shvilo. And in fact, one should do everything one can to try and acquit the accused. Within the rules, of course, but you should explore every possible avenue to find reason to acquit before you actually execute. Although one should not bend the law in order to achieve an acquittal, but one should explore the full ambit within the law in order to achieve an acquittal. As the sages expound, the community shall judge and the community shall acquit. That one should do one's best to try and find a reason to see the merit and to give an acquittal. And if there is in fact merit to this person's case, then you would in fact acquit. And if there is no reason to acquit, then you execute. Alkain, whose harnu sheavo hadin alkol panim lifnei beistin, and therefore, if this is to be done, then you have to bring them before the court. Because if you just see a murder taking place, immediately get out a gun and shoot the guy, you've not gone through the full process of finding if there's some reason to find an acquittal and to let the guy go. V'lo yidinuhu ha'edim sharu hadavar b'nehem la'olam ki ulai mitoch rosam ha'inyan. And the witnesses themselves should not be judges in cases which they've witnessed, because maybe through the very act of seeing this action take place, they can't see the good in the guy. So if you have some independent figure who understands that there are always complexities and can take an objective view of these things, they can make a proper assessment. But if you actually seen somebody plunge the knife into somebody else's back, then that's very hard to achieve that level of objectivity, and that makes you inappropriate to the person to adjudicate the case. You can be a witness, you can't be the adjudicator. Ki yisoro levavam v'chivo al kol panim, because you are so emotionally caught up in the whole case that it's impossible now to be objective. That's why you need both witnesses and judges, and it's judges in a properly constituted court who make the adjudication, make the sentence, and not people acting in a vigilante way, even if they themselves think they've seen some crime take place. Everyone have a good week, and look forward to learning with you next week.